There's a problem in the legal profession that almost nobody talks about openly, but anyone who actually practices law recognizes immediately. Hi, I'm Nate Charles, and welcome back to the Rule of Law Brief. This isn't about ideology. It's not about politics. It's not even about the kinds of bias that you might imagine when you're discussing something like open judicial corruption. It's something more basic, and frankly, it's even more dangerous because it's rooted in basic human psychology. Here's the core of the problem. Judges and experienced lawyers stop looking at what the law actually says at some point in their careers and start substituting their own understanding of what they believe the law says. Now, in some jurisdictions, it's worse than others, but this happens a lot. Not occasionally, not as an exception, as a habit. There is a class of senior practitioners in the law, judges and attorneys alike, who stop working from the text anymore. And instead, they start working from memory, from instinct, from what they believe to be their accumulated experience. The problem is, over time, their perception of what the law is and what the law actually says can drift apart. So you end up in a situation where the actual law, the statute, the case, the governing authority says one thing, but the people who are responsible for applying it are operating off of something else entirely. And that can create enormous problems in a society that purports to be based on the rule of law. You end up with a situation where if you're a litigant or frankly even a lawyer, you can read the law correctly and you can conform your conduct to the law as it's actually written, and you can do everything else right, but then still lose. And at the end of the day, it's not because you misunderstood the law or did anything that was objectively wrong. It's because the decision makers that really matter are applying a version of the law that exists only in their head, not on the page. Now, obviously, this is a fundamental breakdown in the system because the law is supposed to be objective and neutral. When this starts to happen, the system stops being predictable. It stops being something you can rely on. You're no longer operating in an environment where the rule is follow the law and you'll be treated accordingly. You're operating under a system where the rule is conform to what the judge thinks the law is, even if that happens to be wrong. And that's not the rule of law, that's the rule of men. It's authoritarianism under the guise of rule of law. There's a category of lawyer, and if you practice long enough, you know exactly who I'm talking about, and will probably even picture somebody who falls into this category as I'm describing it. That lawyer stopped doing legal research years ago, maybe even decades ago. They don't win because they're right. They don't win because they mastered law. They win because they've mastered the judge. They know the judge's habits. They know the judge's preferences. They know which arguments feel right to the person sitting on the bench. And here's the uncomfortable truth. It works. Not occasionally, not rarely, often. Now, that would be a problem unto itself, but it gets worse. Because in a surprising number of cases, the judge isn't doing rigorous legal analysis anymore either. The judge is operating in the same way as that supposedly learned attorneys standing in front of him, based on intuition, habit, prior rulings, and personal heuristics that may or not have any meaningful connection to the actual text of the law. And so you get a feedback loop. The lawyer plays into the judge's expectations, the judge reinforces the lawyer's approach, and over time, both of their approaches tend to drift further and further away from what the law actually says. Again, this is where the system starts to become personalized, which is the exact opposite of a detached and neutral system under the rule of law. And again, this isn't always obvious, and it's not even willfully corrupt. It doesn't involve any cartoonish backroom dealing, but it's still a problem in a quieter and even more insidious way, where the outcomes depend less on what the law actually says and more on what the decision maker sitting on the bench believes that it says. This phenomenon alters the outcome of cases. And more broadly, it alters the rights and obligations of everyone involved in the court process. Now, I've seen this play out in a variety of ways, but one illustrates the point pretty concretely. I was talking with a relatively senior judge, someone I know socially, and I was venting about a frustration in a case from an entirely different jurisdiction. He offered some unsolicited advice, very confident. He said something to the effect of, in that situation, I always do X. The problem was I immediately recognized that X wasn't just questionable, wasn't just debatable, it was flatly inconsistent and in fact 180 degrees out from what the law actually said. So I asked him if he was sure about that, and he said yes. Then I went back and I actually pulled up the statute involved, the actual text, the black letter law, and I showed it to him. And I point out this isn't a gray area. This isn't even a matter of interpretation. The statute said the opposite of what he had just described. And he didn't accept it. Not because he had a better argument, not because there was really anything ambiguous about the situation, but because he was locked into his prior understanding. His understanding of the law, his subjective understanding of the law, was so ossified that when presented with unassailable evidence otherwise, his cognitive bias would not allow him to change his mind. And this is where human psychology merges with the practice of law. Because what we're describing here isn't just laziness, and it's not just sloppiness. It's actually a pretty disturbing feature of human nature. No one likes to be wrong. And they especially don't like to be wrong about something they've been doing professionally for 20 or 30 years. Something that is central to their self-perception, their identity, how they perceive and evaluate themselves. So once a lawyer or a judge internalizes a certain way of doing things, once they build a mental model of how the law works, sometimes they stop updating it. And even if they try and update their mental model, they will still filter new information through the model of their own perception. They tend to remember the cases that confirm their approach, and they tend to forget the ones that don't. They interpret ambiguity in a way that reinforces what they already believe. And as I said, over time, that ossifies. It hardens into certainty. Not because the law actually supports what they think, but because the human brain prefers consistency over correction. This manifests into a somewhat counterintuitive situation. Young lawyers research the law almost religiously. They don't do it because they're more disciplined, and they don't do it because they're smarter. They zealously research the law because they know they don't know it. They don't trust their instincts yet. So they go back to the primary text, the statutes, the case law, the actual sources of authority. And that humility keeps them anchored to the texts. It keeps them anchored to the objective reality of the situation. The danger I'm talking about here tends to show up on the other end. More experienced practitioners often operate with a high degree of confidence, some of which is entirely earned. But the problem is, over time, they stop checking themselves, not because they're lazy, but because they believe they already know it. The problem is they may not realize that their understanding of the law has slowly drifted away from the objective black paper text of the law. And when that happens, they're no longer operating on what the law actually says. They're operating off of a memory of the law. And in fact, they may even be operating on a memory of 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 the law, filtered and even distorted through years of experience, shortcuts, and prior outcomes. In other words, they've forgotten what the law actually says, and they don't even realize it. Now, pan out from that. If this is happening, even occasionally across thousands of courtrooms throughout the United States, what does that tell you about the rule of law in the United States? It means that outcomes can hinge on inertia, habit, and personality just as much as they hinge on the text of the law. And that should make anyone who cares about the integrity of that system uncomfortable. And now I'm going to take a position that's a little controversial. I think the increased use of artificial intelligence in the legal practice is going to help with this specific problem. It's not because AI is perfect. It isn't. It's because artificial intelligence doesn't have an ego that's tied up in being right. It doesn't have decades of habits that it's trying to defend. It doesn't have a professional identity wrapped around, this is how we've always done it. You can ask it, what does the statute actually say? What does the case law actually say? And it'll give you an answer that is grounded in the text, not memory or instinct or your comfort with your own identity. Now, AI is not going to replace judgment. An IBM engineer once said that a machine should never make a decision because a machine can't be held accountable. And I agree with that 100%. Nor do I think AI is going to replace the role of attorneys in public advocacy. But AI can and should be used to make the law more efficient and to reduce friction in the legal system that is caused by human frailty. AI should act as a check against this slow drift away from the actual law. And we need that. Because even though this form of misconduct isn't dramatic or even intentional, it is slowly eroding the integrity of our legal system. The law has become less about what the law actually says and more about what the people working within the legal system think that it said. And once that gap gets wide enough, there is no rule of law. It's the rule of people. It becomes the rule of men who inherently have subjective perceptions. And that is a bigger problem than most people are willing to admit.